On July 28th, 2020, a group of grassroots reformers filed a challenge to the election of the chair, vice chair, Democratic man, and Democratic woman of the West Virginia Democratic Party. The reason for the challenge is that the election was not done according to the rules of the party. Many rules of the party were violated, as we will lay out. Pat Maroney, on behalf of the people who were challenged in the West Virginia Democratic Party, made several arguments for why our challenge should be dismissed. This video will look at all of the arguments that Pat Maroney made to dismiss the challenge and debunk every single one of them.
In response to this, let me say that the party did, in fact, follow the rules which were in effect at the time. Rule IV4D1 calls for a 5-day notice to be sent out on any election having to do with the party.
Mr. Maroney is correct. The bylaws at that time did say that. And just think about that for a moment. An organizational meeting that typically only happens 1 in every 4 years to elect the officers that run the party, 5 days notice. Is that really a good idea? But let's look at what the DNC charter and bylaws say, because the charter and the bylaws govern the party. So in bylaws, the DNC bylaws, Article 2, Section 3, they lay out how their members are elected. The people who are challenged here is the Democratic man, Democratic woman from West Virginia, and the chair and the vice chair. Because they are, by virtue of their positions, they are on the DNC. But the DNC has their own rules about how their members are selected. Members of the Democratic National Committee shall be selected by each state Democratic Party in accordance with the standards as to participation established under Section 11 of this article through processes which assure full, timely, and equal opportunity to participate. And it should be by one of these methods. The method that West Virginia comes close to is by state committees in an open meeting within the calendar year of the National Convention called after effective public notice of the agenda, effective public notice. It goes on to say that selection by any of the above methods shall be held to meet the requirements of full, timely, and equal opportunity to participate. 5 days is not full, timely, and equal opportunity to participate. As I just read, the selection of members has to be in accordance with standards as to participation established under Section 11 of this article. So let's look at Section 11. This is participation in all party affairs. In Subsection A, participation in the affairs of the Democratic Party shall be open pursuant to the standards of non-discrimination and affirmative action incorporated into the Charter of the Democratic Party of the United States. Subsection B, state Democratic Party organizations shall undertake affirmative action programs designed to encourage the fullest participation of all Democrats in all party affairs. All party affairs shall mean all activities of each official party organization. Such activities shall include, but need not be limited to, the processes in which party officials are nominated or selected. Section C. Each state party shall require each unit of the party which holds such meetings to publicize effectively and in a timely fashion the dates, times, and places of all such meetings. Notice of meetings shall be published as required in this section prior to the meeting. If challenged, a state party shall be deemed to be in compliance with this section upon proof of effective notice from the reporting unit of the party. There has been no proof of notice that fits full, timely, and effective notice of this meeting, as well as inclusion of, in terms of non-discrimination and affirmative action outreach. There's no proof that any of this was done. Summarize, the DNC requirements for the selection of their members, which these four would be, must be in accordance to the standards of participation around participation in all party affairs. It must assure full, timely, and equal opportunity to participate. There must be an effective public notice of the agenda. There could be no discrimination. There must be affirmative action outreach, and it must be publicized effectively. So no, the West Virginia Democrat Party did not follow the notice rules that were in effect at the time because they ignored the charter and bylaw rules about the selection of DNC members.
The Board of Appeals was properly convened. You do not have to be a member of the executive committee to sit on the Board of Appeals. The reason that Kenny Perdue was the chair of this was he was the chair originally when Ms. Vickers filed six challenges. She actually filed 7. So once the new challenge was filed, Mr. Perdue was asked to stay on because Ms. Biafore could not be there because she was one of the persons that was going to be challenged. The vice chair was being challenged. 2 other folks, the second vice chair, and another lady declined to serve. Robert's Rules of Order then allows the chair to appoint any member of the committee. That's in accordance with Robert's Rules of Order.
No, that's not correct. That's not what Roberts says. And I've asked a well-known and well-respected parliamentarian to weigh in on this topic. Mr. Bridgeford, could you introduce yourself?
My name is Charles Bridgeford. I'm a retired professor of English from Concord University. I've been asked to comment on some parliamentary questions. I have a considerable amount of experience in this, having served as president of the faculty for a number of years, and I taught a course in parliamentary procedure at Concord for 15 years.
Okay, thank you. All right, you have listened to Mr. Maroney's statement that the appointment of Kenny Perdue as the chair of the Board of Appeals was proper according to Robert's Rules of Orders. And but the bylaws of the West Virginia Party has very specific states who can be who can preside, the chair, vice chair, second vice chair, and then 2 associate chairs. And he is not any of those. What can you tell us about Robert's Rules of Order? Is the chairwoman allowed to appoint anyone other than those? Can anybody other than those 5 preside over the Board of Appeals according to Roberts?
Well, there are a couple of issues here. One has to do with the nature of the Board of Appeals, whether it's a board or a committee, because the rules for the appointment of members to boards and the committees are different. The bylaws refer to it as a board, and it has what Roberts considers the characteristics of a board. That is that it is allowed to take independent action, subject, of course, to the review of a larger body. But if the body declines to review it, then what it says goes, whereas committees merely report their findings. The Board of Appeals says that the State Executive Committee chair shall also serve as the chair of the Board of Appeals. Under the Executive Committee, it lists a chain of people who can replace her, but there's only a limited number there. There are 5 listed, and where bylaws list specific possibilities, the presumption is that there are no other possibilities. Roberts, Section 49 on boards states, and I quote, "A society has no executive board, nor can its officers act as a board, except except as the bylaws may provide. And when so established, the board has only such power as is delegated to it by the bylaws or by a vote of the society's assembly for individual matters to it. So only the bylaws govern here, and if there is no provision in the bylaws, there is no board, according to Roberts. Now, if you were to consider it a committee, which would be problematic, it's also not invariably the case that even the chair of a committee has the right to appoint the members. If there's a bylaw specification on that, then Roberts doesn't apply. So that would be my view.
Then in the Board of Appeal, in Article 7, Section A, it states that the chair shall preside but have no vote except in case of a tie. On top of the fact that a person who is not allowed through the bylaws or through Roberts to preside over the meeting voted on, not only presided over this board, but then voted. Is that allowed in any shape or form?
Well, this is another difference between committees and boards. The idea of the chair voting is frequently and generally done in committees, but it's not done in the board. And here the bylaws specifically prohibit that, or whether they specify cases where it can be done. When they say shall have no vote except in a case of a tie, it means they will have no vote except in case of a tie. It's hard to be any clearer than that.
In your opinion, was the Board of Appeals properly constituted? The West Virginia Board of Appeals that had Kenny Perdue as chair and voting, was that properly constituted?
No, if it does not have one of the designated people presiding over the meeting, then it doesn't meet the requirements set out here in Article 7, Section A, in my opinion.
Pat's point number 2, that the Board of Appeals was properly convened, is debunked. Kenny Perdue was not allowed to preside over that committee, and he was not allowed to vote on that committee. According to the parliamentarian, there is nothing in Robert's rules that would allow either of those things to happen. This point is debunked. If nothing else about this was addressed, this information alone that Mr. Britchford provided is more than enough proof to dismiss the decision of the Board of Appeals because it was not properly constituted.
The next item which we would talk about here, and I think we look first at what the challengers have said. If you look at what she has filed with you folks, it begins with this, that there was 5 days notice. One paragraph which she has, she says, the challenge was related to the election of June 29th. You all know you were sent an email. She puts that right in a document that she sent to you on Sunday about a 5-day notice before the meeting. In fact, the notice was actually sent 9 days before to all members of the committee.
Here's the document that I sent on Sunday to the state executive committee members. I've done a search through this to see if what he's saying is anywhere in here. There was nowhere in this document that I could find what he is saying. I also thought that perhaps he meant the original challenge. I went back and looked at it. I could not find that. So I can't prove a negative, but if he doesn't say which paragraph it's in, I don't know that, there's nothing I can do about that. But regardless, even if I had said that, which I don't think I did, but even if I had, that sending an email to just the executive committee is not proper notice. As we went over at the beginning, these are DNC members, and the DNC bylaws have specific requirements for how their members are elected. Again, they have to be in accordance with standards of participation. They must, that are outlined in Article 2, Section 11 of the DNC bylaws. They must assure full, timely, and equal opportunity to participate, must have effective public notice of the agenda, can be no discrimination, must have affirmative action outreach, and must publicize effectively. I reviewed the document that I sent to the Executive Committee on Sunday and could not find the statement that Pat said that I made. However, even if I had made it, perhaps it's in another document, I don't know, but his implication was that if there was 5 days notice just to the Executive Committee, that was proper notice, and that has been thoroughly debunked.
In addition to that, and it was Exhibits 7 through 12 of the response which was filed, there was a email notice that went out, a notice that went out by email to the press, which fully explained, and that was Exhibit 7, which was sent to you folks. Then on Exhibit 8, there was another Zoom meeting notice that was sent out. Another notice sent out on, which is Exhibit 9. Exhibit 10 was another notice, all of them giving more than 5 days notice. In fact, the original notice was 9 days.
Well, let's look closely at these exhibits. So in Exhibit 7, this is a screenshot off of the WVDM's website, and it's under blog/press releases. And it looks as if that it is a press release that has been sent out to the media. However, just because it's posted on the website under press releases doesn't mean that it actually goes out. So I've suspected for a long time that the things that the Dem Party puts on their press release section doesn't actually go out to press releases. So what I did is I contacted, I attempted to contact every one of these groups. However, I didn't get a hold of everybody. But what I did, I spoke to Jeff Jenkins at the WV Metro News. Mr. Jenkins informed me that he had access to the email where press releases were received. He searched that inbox and he found he searched other folders. He found several emails from the state party around that time, which had been around June 20, 2020, but did not find an email announcing a meeting to be held on June 29th. I also spoke to Samantha Cassino at WYTV and spoke with her. She checks the inbox and has access to the inbox where press releases are come. She found 2 emails from the state party dated June the 18th, and another one, she found one on June the 29th, but she did not find any email from the state party announcing a meeting to be held on June 29th. I also spoke to Marky Owens at WSAZ, and Marky said that she monitors the inbox for press releases. She informed me that she had access to the email where press releases were received, searched that inbox and other folders. She found several emails from the state party around that time, but did not find an email from the state party announcing a meeting to be held on June 29th. And I also spoke to Nicole Fields at the Herald-Dispatch, and she informed me that she had access to the email where they were received. She searched that inbox and other folders. She did have an email from the state party dated June 23rd, something about Attorney General race. She did not find an email from the state party announcing a meeting to be held on June 29th. So it's impossible to prove a negative, but by contacting these people and none of them finding any of these emails highly suggests that it wasn't actually sent out. Furthermore, it would have been very simple for the party to provide an email receipt that was sent out to show that it was sent. That was not done. That the only proof, if you want to call it proof, that they have that this was sent is just Chair Biafore claiming that it was done. There's no proof that this press release actually went out to the press. I signed a sworn affidavit to those conversations. Exhibit number 8 appears to be on West Virginia Democratic Party letterhead. It has a date of June 20th on it, and it has attention, WV State Executive Committee members. It has, information about how to join the Zoom meeting, and it lists the agenda. This provides zero proof that was actually sent out to anybody. This is just some information on letterhead. Exhibit number 9. This looks like a flyer. It has, it says agenda. It has how to join a Zoom meeting. It lists 3 agenda items. This is no proof that this went out to anyone. This appears to be a screenshot from the West Virginia Democratic Party website on their calendar event area. You can click on a calendar item and it gives you some more details. That's what this appears to be. So what it proves, I think, it doesn't even list the URLs, but I believe that this would prove that it was posted on the website. This is a screenshot. It doesn't prove that it was sent out anything past their website. Mr. Maroney offered these exhibits as proof that these were sent out to the public, to the press, but in fact, none of them provide any proof whatsoever. They are simply copies and screenshots. There is no evidence that these were mailed or emailed to anyone. And the DNC bylaws say that if challenged, which they were challenged, that the state party shall be deemed to be in compliance upon proof of effective notice. So they did have a burden to provide proof, and screenshots of pieces of paper are not proof.
In addition to that, the challengers are saying that this was accepted by the DNC. It was not. It was filed with the DNC, but not accepted. It was then referred to the committee here for a review, and it went to the to the appeal board. When we look at what the appeal board actually did, they heard evidence from her. They heard the evidence from Ms. Biafore. They had the exhibits which were attached to the response which was filed with this committee and also with the DNC. Now, she is saying in her presentation that there had to be a notice filed with the DNC, and that's absolutely correct. But the rules of procedure and the charter of the DNC specifically say this, that the notice must be sent, and I'm going to quote from the bylaws attached to the charter of the DNC, that any challenge to the credentials of a member of the Democratic National Committee may be made by any Democrat from the state or territory of the member challenged, and it shall be filed by registered mail, return receipt requested. Ms. Vickers was asked on 2 occasions by the board, the appeal board, to file the return receipt requested, which she never filed. At the day of the hearing, she admitted that she had not sent it by registered mail, return receipt requested. In addition to that, the rules of procedure of the Credentials Committee also require that any challenge to the seating of a member of the National Committee that is not made in conformity with these rules shall be deemed waived. The rules say that it shall be filed by registered mail within 30 days of the selection of such member. She did not file it within the 30-day period, and that issue is still to be determined and it was determined by the appeal board.
All right, there's several things to note here. Here are the rules of procedure for the Credentials Committee of the Democratic National Committee. This is the committee in which this challenge has been filed. So there's a couple things that's important to note in here. One is that it says that when interpreting these rules, the co-chairs of the Credentials Committee may reference prior rulings of the chairs or co-chairs of previous credentials committees and the decision of other credentials committee and any precedent that has been set by other committees. So then under challenges, it has filing and service. So it does talk about how it should be filed, registered mail, return receipt requested. In lieu of that, though, such materials may be hand-delivered or sent by overnight delivery. And the most important thing here, with proof of delivery, and here with return receipt requested, proof of delivery, and it has to be within 30 days. All right, so then this is an email between Harold Ickes, who's a DNC Rules and Bylaws Committee member, and Patrice Taylor, who is a senior advisor and kind of over the Credentials Committee and the RBC Committee. She's who you send, that you file when you're filing to the DNC. This is who you file with. And so Harold asked her questions about a filing to the Credentials Committee, and she says, now this is the Convention's Credentials Committee. That's a different, just so you know, that's a different committee. That's to the National Democratic Convention that was held in Milwaukee. This is to their Credentials Committee that is completely separate, all right? But he asked if, and this is probably, because of COVID, will they permit documents to be filed by email, which is not currently authorized by the rules. The convention rules do not have email filing. And Patrice responds, the co-chairs have confirmed that they will permit electronic email submissions. Now, here is, remember how we talked about proof of receipt. That's the most important thing. So here is my email. I had sent this to Belinda, and then I sent it to Patrice Taylor. It was delivered after 0 seconds. So not overnight, delivered electronically. Now here is what proof of receipt looks like, right? And I could go on to, I could, do a Zoom screen share and show how I come up with this so that's not like made up, but I can do that. But this very long, complicated thing, please forward the challenge attached to the Credentials Committee and consider it filed with the DNC Credentials Committee. I'm attaching the certificate of service as well. And then here's the original message that I sent to Chair Biafore. And this, I don't even know what all those things mean, but this is what an electronic receipt of an email looks like. It's like 3 pages long again. Oh, here's all the exhibits. It has all the exhibits that were sent that are attached with it. So that is proof that this was filed, and this was filed actually 1 day early. This was filed with the DNC, and this shows proof that that was done. Now, keep in mind that this challenge was filed in July of 2020, right in the middle of the pandemic. And lots of organizations made changes to what were their normal procedures in order to make things safe for people. So one of the things that they did was to allow people who file challenges to file them electronically, so you don't have to go to the post office and touch door handles and handle money and be exposed to other people. They made the DNC made the decision to allow the filing of challenges electronically. That's what happened, and that's what we did. And it's important to note that nowhere in the rules does it forbid the filing of electronically. It says that you can send it overnight. We sent it within, less than a second, and it was filed. And the reason that we know that it was accepted is there is no way whatsoever that the DNC would ask the West Virginia to go through this whole rigmarole and to have a Board of Appeals hearing and to have, an appeal hearing with the executive committee. If they had not accepted this challenge, they would have said it wasn't filed properly, we reject it, and that would have been the end of it. The challenge was filed properly with the DNC Credentials Committee within the time limit allowed. This challenge was properly filed, and it has been accepted by the DNC Credentials Committee.
In addition to that, the challenge, which was filed by her, was responded to, and the previous 6 challenges which she had filed, she entered into what was called a memorandum of understanding with Ms. Biafore. With that memorandum of understanding, she was giving up those 6 challenges. She was striking them, and that memorandum of understanding was filed with the answer that it was filed with this committee. And here's what the exact language from that memorandum of understanding. Selena Vickers, and I'm quoting now, on behalf of all of the challengers, automatically withdraws all challenges pending before the Credentials Committee. That was signed on June the 26th. On July the 14th, she had filed a challenge which is exactly like the one that she then ended up filing again on July the 28th. Exactly the same challenge, which she had withdrawn 2 days before. She is not complying with the agreement which she entered into. The agreement that she entered into is exactly what you folks voted on 10 minutes ago. The changing and the updating of the bylaws of the State Executive Committee. She has violated that agreement herself. She then refused to abide by an agreement that she signed. She uses the language that it was not withdrawn with prejudice. Prejudice has nothing to do with this. She violated the agreement 2 days after she had withdrawn the exact same challenge that she had filed on July the 14th. That is not good faith. She then, on July the 29th, even after she had filed the new challenge on the 28th, sent a memorandum on July the 29th, and she called it a historic memo of understanding. Well, in that, she said, and it went to the West Virginia State Democratic Executive members, you folks, to the Standing Committee of the 2020 Convention Committee members, the delegates to the committee, to the convention, and here's exactly what she says. While I would, upon the execution of each party's signature to the attached memorandum of understanding, I withdrew the 6 pending challenges to the 3. So she had withdrawn it, and then within 2 days, refiles it. Now that is not good faith. That is anything but good faith.
Okay, so this is going to be fun to debunk. This is the memo of understanding that was signed, and it's important here to note as the West Virginia Democrats are Selena Vickers and many other Democrats. We're referred to as challengers. The Rules and Bylaws Committee refers as the RBC. The Democratic National Committee is referred to as the DNC. And this is important. The Standing Committee on Credentials of the 2020 Democratic National Convention. Okay, that was the convention credentials committee that met in Milwaukee. Right, that's referred to as the Credentials Committee. Right, so it has a bunch of whereases. You should probably read this because it's really cool. And then, all right, now therefore, Selena Vickers, on behalf of the challengers, automatically withdraws all challenges pending before the Credentials Committee and the Rules and Bylaws Committee upon execution of this agreement by all parties. Now, remember, the Credentials Committee is the Credentials Committee of the National Convention and the Rules and Bylaws Committee. Now, I did that. I withdrew all of those challenges. Now, just to show you, and this is our agreement where they have to, do certain things and they have to change their bylaws to let people participate. And then here at the bottom, I signed it, Belinda Biafore signed it, and then Jim Roosevelt and Lorraine Miller of the RBC signed it. I signed it on the 25th, Belinda on the 25th, and they did it on the 26th. This was the agreement, and I withdrew those challenges that were pending before the RBC and the Standing Committee on Credentials of the 2020 Democratic National Convention. This is the challenge that was filed on July the 14th of 2020. As you can see underlined, this challenge was to the Democratic National Convention Standing Committee on Credentials. This challenge was withdrawn after I signed the MOU. Now, this is the memorandum that I called Historic Agreement. I did. This was on July 28th, 3 days after I signed the MOU. And I sent it to a whole bunch of people. And it says, upon the execution of each party's signature to the attached, I sent him a copy of the MOU, I withdrew the 6 pending challenges to, the 3 standing committee members and the West Virginia Democratic delegation to the 2020 Democratic National Convention and the West Virginia Democratic presidential elector nominees. Nowhere in here does it say anything at all about withdrawing a challenge to the credentials of the Democratic man and woman and chair and vice chair and their credentials to the Democratic National Committee. This was the challenge that was filed July 28th, and it was not included in that memo that I sent out to the Executive Committee. This was to the Democratic National Committee Credentials Committee. Completely separate challenge, completely separate committee, completely separate rules of each of those committees. I really don't know if Mr. Maroney doesn't understand that these are 2 different challenges, or if he's just intentionally trying to muddy the waters and convince people that these are the same just simply because they have the word credential in both of the titles. The July 14th challenge was to the Credentials Committee of the Convention. Completely separate committee, completely separate rules, completely separate challenge. That was what I agreed to withdraw in the MOU. I kept my agreement and withdrew it. The July 28th challenge, which is the current challenge that we're talking about, that is a completely separate challenge to a different credentials committee, to the Democratic National Committee. Completely separate. They have their own rules. They're completely different people. This is a completely different challenge, asking completely different things.
It was fully advertised via the West Virginia party's online, and it did go out to some 30,000 people. Ms. Biafore testified to that before the committee. In addition to that, it was in the verified answer to the challenge, which was sent both to this committee and to the DNC.
This is what he's referring to in Chair Biafore's answer, which he made a big deal about it being verified and blah, blah, blah. She just sent in an answer that she was required to related to the challenge. And in it, and she signed onto this and said that this was sent to the notice of this meeting was sent to 30,000 West Virginia Democrats on June 20th. And she offers Exhibit 8 and 9 as proof of that. And to remind you, Exhibit 8 is some information on letterhead, no proof that it was sent to anybody. And Exhibit 9 is just some information on a piece of paper. Again, no proof that this was actually sent to anyone.
The newspaper advertisement was made in the Charleston Gazette, and in addition to that, the Democratic Party, via Bridget McGuire, sent to the following newspapers the notice, and not only the newspapers, but the television and radio, talk radio, AP, the Exponent Telegram, West Virginia Public Broadcasting, WOWK, WSAZ, the Intelligencer, the Herald Dispatch, and the Charleston Gazette. But in addition to that, when you send it to the newspaper, which is a combination, it also goes to numerous other newspapers. And that's the Williamson paper, the Logan paper, the Lincoln paper, and others throughout West Virginia. There is no question that this party fully complied with the party rules in advertising and giving notice for this election, which took place on June the 29th.
This is a legal ad that was placed in the Charleston Gazette Mail. This was placed on June 24th, which was 5 days before the meeting. All right. Now, this is what it says. The West Virginia Democratic State Executive Committee will meet, Monday, July 29th, 2020 at 6:30 p.m. Agenda, update on convention, election of officers, announcements. Now, there are a little bit more there, but that's the content of it, right? 5 days before the election. Now, do you think that 5 days notice allowed for full, timely, and equal opportunity to participate for all West Virginia Democrats? And let me ask you this. Which offices were up for election? What are the qualifications for those offices? It doesn't say. How do you apply to run for those offices? It doesn't say. Oh, and remember that there were 3 at-large members, the positions that were to be filled that day. This notice says nothing about those at-large positions. If you were interested in running for office of the Democratic Party, would 5 days be enough to campaign for one of the four most powerful positions in the party? I don't think so. Now, let's say that you just wanted to attend this meeting. Now, from what is on that legal ad right there that was printed in the Charleston Gazette Mail, where would you go if you wanted to attend that meeting? There's no location mentioned in that ad. Now, you and I know that it was a Zoom meeting, but there's no Zoom link provided in that. How would somebody know what to do? How could anyone consider this newspaper ad a full, timely, and equal opportunity for people to participate and for people to be able to run for these positions. It isn't. This is not in accord with the standards of participation related to participation in all party affairs. This does not assure full, timely, and equal opportunity to participate. This does not provide effective public notice of the agenda. It doesn't even have all the agenda items on it and other positions. This is discriminatory because it doesn't even let people know where to go or how to participate. And remember, one of the important things that must happen is affirmative action outreach. There's no proof that that was done in any way whatsoever. And they must publicize effectively. How could a notice that doesn't even have the correct information or how to participate, how could that possibly be considered effective publication of that meeting? This Charleston Gazette ad does not meet the requirements for proper notice according to the DNC bylaws, and therefore it is debunked. This is what the West Virginia Democratic Party bylaws say about the media, that you have to release a story to the major newspapers of the state. So here's what was allegedly released as a press release. So it has some information about the agenda, which is not complete, and a link to a Zoom meeting. There's no story there. But regardless of that, there is no evidence that this press release went out. If you do a Google search of June 29th, West Virginia Democratic Executive Committee, you will find no story, no information whatsoever that was picked up by any news outlet whatsoever announcing this meeting ahead of time. If you could, then that would prove that at least somebody got it, but there is no proof that this did anything other than sit on the website. It does not consider it a press release unless it's actually released. It doesn't matter whether it has press release listed at the top. I went over earlier in this video that I contacted everybody that on that list. I was able to speak to 4 people who have access to the inboxes of press releases. They could find press releases from the West Virginia Democratic Party in June of 2020, but they could not find a press release that gave an announcement about this meeting. This was not sent out to any press, period. And even if it were, even if that plain Jane press release that said agenda, update on convention, election of officers, and announcement, even if that had went out to the press, and even if they had printed it, even then it would not have met the requirements of the DNC. It was not in accordance with the standards of participation. It did not assure full, timely, and equal opportunity to participate because it doesn't even list all the offices or how to participate. There's not enough, even if it was sent out 9 days in advance, which it was not. That is not enough time to have effective public notice and full, timely, and equal opportunity to participate. The fact that it didn't, there's no proof whatsoever that this went out, is discriminatory. The only people who had access to win the elections, full, timely access to this information, was a handful of insiders. All of those diversity groups and other low and moderate income Democrats who would have wanted to participate did not have a full, timely, and equal opportunity to participate. There was no affirmative action done, and this was not publicized effectively. What is important to know is that in the hearing, Chair Biafore claimed that she sent the 30,000 emails out through a program called VAN, Voter Action Network. We had a communications expert testify that if that system had been used, it would be simple, like within seconds, a report could be produced. There was no report produced. I showed you one of my email receipts. That would be simple to do, to provide proof that these things went out. There is no proof whatsoever that any of this was, that it went out. The only things that we know for sure went out was an email on June the 23rd to executive committee members only with a limited amount of information, and the legal notice in the Charleston Gazette Mail, which we have already proved was not effective notice. It did not have a full agenda. It didn't even tell people how to participate. Having ineffective, incomplete information that sits on a website is not effective notice. Spouting off a bunch of names of press organizations without showing a drop of proof that any of this was done is unacceptable, and that point is debunked.
And what we're respectfully requesting is that, number one, that you find that the challengers did not show by any evidence whatsoever that the party failed to do what it was supposed to do in notifying Democrats of the meeting of June the 29th. The burden of proof is on them. But in addition to that, in addition to all of that, this party has shown, and that's what the appeal board found, was that the party had done exactly what it was supposed to do. And when you read the findings of the appeal board, that the appeal board found specifically that the party, your party, had complied fully. In addition to that, they found that she did not file it within the 30 days as required by the rules of the Democratic National Committee, and that she had violated the agreement that she signed on June the 26th by refiling exactly the same challenge that she had filed on July the 14th, which is not a showing of good faith. We are respectfully requesting that this committee find that she has not prevailed, that the committee did in fact do what it was supposed to do and fully advertised the election of June the 29th. You will be asked to vote on this, and it will come to you, as I understand it, in some kind of written form in the next 24 hours for you to vote on it. We're respectfully requesting that you reject the challenge of Mrs. Vickers and the others and state and find that the party fully complied with what it needs to do to have an election as it did on June the 29th. Thank you very much.
This is the second part of the ballot that executive committee members will receive. This says, do you vote to uphold the decision of the West Virginia Democratic Party Appeals Board, which will dismiss the challenge filed by Selena Vickers et al.? You must vote nay on this ballot if you are to follow the rules of the Democratic Party. Just the fact alone that the Board of Appeals is not properly constituted, that alone is enough. But on the substantive issues, we have laid out and debunked every reason that Mr. Maroney provided as the reason to dismiss this challenge. This challenge should be accepted, and new elections for the chair, vice chair, Democratic man, and Democratic woman should be held in full compliance of all of the national rules that govern the selection of D and C members. Thank you.